This is your Indian law portion for the South Dakota bar exam. Indian land, what is Indian land? Indian land is within the reservation. It's dependent Indian communities, Indian allotments, even reservation land owned by non-Indians in fee is still Indian country. You own it in fee, however, it's within the reservation, that's Indian country. Looking at jurisdiction of the tribe, we're going to talk about civil and criminal jurisdiction on the exam. You're not going to be asked about Indian law, Indian tribal law. It's basically going to boil down to, does the tribe have jurisdiction, or what would be an appropriate venue to adjudicate the dispute? Looking at jurisdiction of the tribe, generally tribes cannot exercise criminal or civil jurisdiction as generally over non-Indian offenders. They have jurisdiction over non-member Indians, so members of other tribes. So tribe has jurisdiction over Indians. They don't have jurisdiction over individuals that are not Indians. Now, when you have an Indian victim and a non-Indian offender, federal government has exclusive jurisdiction. This is in a criminal context. In a criminal context where there's an Indian victim versus a non-Indian offender, the federal government has exclusive jurisdiction. Where both the offender and the victim are not Indian, the state has exclusive jurisdiction. The tribe has no jurisdiction over non-Indians. Exceptions to criminal jurisdiction under the Violence Against Women Act of 2013, if it is adopted by the tribes may try non-Indians who commit domestic violence on tribal land against a tribal member. Non-Indian must have sufficient ties to the tribe. And sufficient ties, you can look at where they live, how they interact in the community, social services, government interaction, that type of thing. Exceptions in civil jurisdiction, again, because generally tribes cannot exercise criminal or civil jurisdiction over non-Indian offenders. The tribe may have civil jurisdiction where the non-member entered a consensual relationship with the tribe or its members, and that could be like a contract. The non-member is within the reservation where the non-member conduct threatens or has some effect on the tribe, such as political integrity, welfare, safety of the community, or where Congress has authorized jurisdiction, or where the non-Indian consents to jurisdiction, such as you're sued in tribal court, you file a counterclaim, you're consenting to jurisdiction. Now, determining who constitutes a non-member Indian, you consider enrollment in a tribe, the degree the individual has received federal services and benefits for non-Indians or for Indians, where they have benefited from tribal rights or services, whether they have participated in tribal ceremonies and social life. Okay, jurisdiction of the state in criminal proceedings. The state has jurisdiction of Indians and non-Indians for conduct off of tribal lands. State generally has no jurisdiction over Indians on tribal land. However, the state may execute a search warrant on tribal lands for crimes committed off tribal lands, and the state may pursue Indian into tribal lands and arrest for crimes committed off of tribal lands. And a double jeopardy in criminal proceedings in Indian law. There's no double jeopardy between tribal, state, and federal governments. Here, it's just like the state and federal government. There's no double jeopardy. The tribe can try you, the state can try you, the federal government can try you, individually or concurrently. Jurisdiction in the civil context, this is very complicated. As I said earlier, the tribe cannot exercise jurisdiction over non-Indians. However, again, it's complicated. The tribe may have jurisdiction over non-Indians based on consensual relationships. As I stated earlier, exceptions in civil are you enter a consensual relationship such as a contract, you may consent to jurisdiction. So, based on consensual relationship, an example is commercial dealings, contracts, leases. So you're a non-Indian, you go to the tribe or tribal grounds, you engage in commercial dealings or a contract, or you lease an apartment or a condo, you may have consented to civil jurisdiction in that context. Now, over non-Indians, this is very narrowly interpreted, and the federal courts, just based on this consensual relationship, rarely find tribal jurisdiction here. They may have tribal jurisdiction, or the tribe may have, again, jurisdiction over non-Indians, non-members, where the consensual relationship exists, the consensual relationship is private, or there's a threat to tribal integrity. That's a very limited exception. So again, they may have civil jurisdiction where a consensual relationship exists, and that means the non-Indian conduct at issue must specifically be related to the consensual relationship. Here you have a contract with the tribe, that's the relationship, for landscaping. This contract did not give the tribe jurisdiction over an accident on a state highway through tribal land where the landscaper was named as a defendant. Here, again, the consensual relationship must be private. And what does this mean? This means that the consensual relationship must be between private parties, cannot be based on the tribe suing a state or state officers acting in official capacities. As I said earlier, officers could come into the tribal land and file and execute a search warrant. That activity is not a basis for a consensual relationship. It must be private. Now, another grounds separate from the consensual relationship context where the tribe may have jurisdiction is where there is a threat to tribal integrity. Now, there's this very limited exception. It must, quote, imperil the political integrity of the tribe. Now here the example was in an election dispute, non-members raid a tribal government buildings and casino because of the control over the government buildings and the casino, the economic engine of the tribe. Those non-members, the tribe was given jurisdiction over those non-members. Now jurisdiction in a civil context in child welfare actions, specific to child welfare actions. The Indian Child Welfare Act provides exclusive tribal jurisdiction if the individual is unmarried, under 18, member of the tribe, or eligible for membership, and is biological child of member of the tribe. This does not apply to custody hearings during divorce proceedings. Indian Child Welfare Act. The tribe provides exclusive tribal jurisdiction if the child is unmarried, they're under the age of 18, they're a member of the tribe or eligible for membership, and is a biological child of a member of the tribe. And that completes all of Indian law for the South Dakota bar exam.